how to appeal your divorce. Appeal. Okay, that was horrible. Sorry about that. Corny jokes aside, an appeal. So you don't like your divorce judgment. Is that why you're watching this? You got the trial court order back and you take issue with it. So sometimes that issue that you're taking with it is warranted. And that's why there's an appellate process. There's checks and balances. The trial court judges in Florida, the checks and balances are there's somebody else above them that looks at it. That's the process. They understand that. They're aware of it. Hopefully your attorney was aware of it as well, and hopefully there's a transcript of your proceeding that you're trying to appeal. If there's no transcript, that's a little bit more complicated and not gonna go into that in this video. There's a couple things you need to figure out first is what is the reasoning for your appeal? What are you trying to do? Did you just not like the judge's decision, or did the judge actually commit some type of an error? Because that's what the appellate courts are looking at. You can spend a lot of money on appeal and not get anywhere with it if the court did not commit error. They're looking for error to be committed. That's something that you need to think long and hard and speak with an attorney and strategize of, is it worth it to appeal it? Most cases are not appealed, but there's still a lot out there, and there are a lot of cases that get overturned. We've had cases be remanded back for the trial court to make decisions that were not consistent with the trial court's ruling. So it does happen, but not all the time. So that's something that you need to really take some time and think about, because you could get into the middle of an appeal and then, for a year, you're just there. You're locked into it. So you need to talk to an attorney about it first. So speak to an attorney, get some information about what the next steps are. After you've received your final judgment of divorce, the checks and balances portion of it is the trial court's here, and then the appellate court looks over what the trial court does if you appeal it. They're not just sitting there burning the midnight oil looking over trial court judgments to see if there's some error committed. You have to file a notice of appeal and go through the process of getting the transcripts, getting the court record, filing an appellate brief. There's a significant process that's behind an appeal. So understand that. And then at the highest level is in Florida, is the Florida Supreme Court. And I think you could understand that not a lot of cases go there, and it's for issues that there's a lot of problems between the different districts. So there's in Tampa, in this area of the region, the Gulf Coast of Florida that I practice in primarily, it's called the Second District Court of Appeals, the Second DCA. So it encompasses a bunch of different counties around the Tampa Bay area, and that's where a lot of our cases come from. Now, I practice all around the state, so I have cases in the trial courts, all over the place, but the vast majority of cases that we do are in the Second DCA. So that's primarily what I'm speaking from when I'm talking about this video. The Second DCA, when they receive it, they're going to make a decision after the process is followed, and then they will enter an order, and if there's no motion for rehearing on that, then there's a mandate that comes out, and then that's the end of the case, depending on if it's affirmed, if it's remanded back, then there's remand hearings. But like I said, most of them don't go all the way up to the Supreme Court of Florida. But what we're talking primarily about is at that trial court level that you've received a final judgment of your divorce. And I'm a Florida divorce and family law attorney, so I primarily do just divorce-related matters. I do some family law related issues. That's all we do. It's just divorce and family law. Foley Divorce. Subscribe to our channel below. Somewhere around here. Hit the subscribe button if you're getting anything out of this. If you're not, I'm sorry. I apologize. You can comment and let me know how I can help. We make these videos to help people learn and help people understand the process. I've been doing this for 15 years, and I've gotten a lot of good information and a lot of good experience, and I think it's helpful for people to have it. Most divorce-related judgments are not meant for anybody to walk out and say, I love my divorce judgment. Every once in a while they'll come up, but most of the time it's both parties are looking at it and saying, it's not exactly what I expected. That's kind of a compromise point. That's really also what you're seeing in settlement agreements, marital settlement agreements. It's compromise. It's both parties being a little bit unequally unhappy. But if there's true error or there's a true just departure from settled law, you speak to an attorney, decide if you have an issue that's appealable and that makes sense to do it. You file a motion for rehearing. If that gets denied, that's basically your final word. And this isn't a one-size-fits-all approach. There's, speak to an appellate attorney if you have questions about it. But I'm just saying that's the normal route, at least that we've seen, is, when that order comes back denying the motion for rehearing, then 30 days from there is, within that 30 days, you file your notice of appeal. So you file the notice of appeal and you start down the process of, money, okay? Money. You got to pay a filing fee with the trial court. You got to pay a filing fee with the appellate court. You got to pay the clerk's office to create the record that's certified and, that's then transmitted to the appellate court. You got to pay for the transcripts from the trial. So let's say you got a 3-day trial. That's got to be transcribed. The court needs to see that, and then your appellate brief is going to be citing various portions of that transcript. So and then your attorney that's working on this has to do this and have to devote a significant amount of time in order to prepare the appellate brief. That's the next step. Preparation of the initial appellate brief. Very time consuming, not easy. You got to formulate the areas where you felt that the trial court made an error. You have to set up the different standards of review. You have to go through it. Then you have to do the law and the case analysis. You have to analyze everything, and you have to put it out there and give the court an understanding of why you feel that there was error made at the trial level and why the appellate court should become involved now and take a look at this. So the initial brief is extraordinarily important and time-consuming. The other side has the ability to reply to your appellate brief. So that initial brief is now replied to. The Florida Rules of Appellate Procedure very clearly delineate what needs to be done within what period of time, what font you need to use. That did change, by the way. So there's all these different things that the Florida Rules of Appellate Procedure are very instrumental in giving this information. So take a look at that. After the response brief by the other side is filed, then you get a chance to file a reply brief. Each one's a little bit shorter, but still it's seeing the progression of it. Then there's the possibility of oral arguments. These do not happen as often. I think some appellate attorneys, especially trial attorneys, they're kind of excited about it. If the court does grant oral arguments, they get a chance that they can argue their case, or usually it's not the whole case. The appellate court needs, their, I don't know if the word struggling with an issue is the right, but they're looking into it and they want to hear some argument from both sides on that issue or the issues that they're looking into within the appeal. That's the progression. After all that's resolved, and there's exceptions in every case. There's other things. This isn't to go into every single different type of appeal. Again, I'm not your attorney. I'm not, this isn't legal advice. Just understand, speak to an appellate attorney if you have those questions. I'm just giving a little bit of a roadmap. But the next step normally is you're waiting. Wait. And then finally one day, magically, this order comes out. And if you're a litigant in it and the other side has appealed you, you want it to say the word affirmed. 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 And sometimes clients will get that and they'll just look at it and say, what? We'll say, no, it's a good thing. It's a really, really, really good thing. You want it affirmed. That's if you're defending against it. If you're appealing it, if you see affirmed, that means, unless you do a rehearing or whatever, but for all intents and purposes of this video, it's over. If there's a remand or there's some specific directions by the appellate court, they'll state it within the order. But then again, if there's no motion for rehearing or anything else, any other type of pleading after that, there's usually a mandate that that's the final order. And now your case is done. So that's a little bit of a roadmap of how to appeal a Florida divorce trial judgment. Again, this is Foley Divorce. Subscribe to our channel if you're so inclined, and watch our videos, and let us know any other issues that you have questions about. Thank you so much for watching.